My Lords, I appear for the Appellant, Greenfields, Isle of Wight Limited, together with my learned friend Mr. Brett. My learned friend Dr. Bowes appears for the respondent, the Isle of Wight Council.
Yes. Now, before we begin, may I mention that one member of the Constitution who was due to sit today is not feeling well, and so we are minded to proceed as a two-member court, but we do want to know what the parties' views are on that.
Yes, my Lord, I have canvassed that with my son and we have no objection.
Thank you.
Same here, my Lord.
Very good. Then we'll proceed. Thank
I'm grateful. May I begin, my Lord, with some housekeeping?
Yes.
I'm afraid there is slightly more than I might like. So in terms of bundles, hopefully you have three, a
Yes.
core bundle, a supplementary bundle and an authorities bundle.
Thank you, yes.
There are some variations and amendments, and I'm not entirely sure to what extent those have already been made to the court's bundles.
Certainly, speaking for myself, my clerk, I think, has inserted new documents when they've been sent to us.
I'm grateful.
My clerk inserted new entries into the authorities bundle, including the statute on which you're relying, and I was sent some emails yesterday, which I put at the back of my own prepared bundle. So those are the two sets of documents I've had, some authorities and some emails.
I'm grateful. There is one further amendment in terms of authorities because it is the wrong United Trade Action Group case which is in the authorities bundle. And so I have brought a replacement with pagination that could go in behind tab 25.
This is very disappointing to me because it means that my judgment comes out.
Yes, my Lord. And I think Lord Justice Phillips, who would have been with us.
Oh, yes.
I remember it well.
Right, thank you for that.
My Lord, then, there are two procedural points I just wish briefly to canvass. The first relates to paragraph 32 of my learned friend's skeleton, which relies upon evidence permission to admit which was refused by Lord Justice Lewison. The court will find that at paragraph 4 of his order on page 317 of the core bundle. So my submission is that paragraph should be ignored.
Well, you won't have any evidence to support it.
No, precisely.
An assertion would be a very interesting assertion, but what else is he going to assert, you will say? Yeah.
Precisely, my Lord. So that is a very simple point. The second relates to my undetermined application on the new point, as I say it is taken at paragraph 35 of my learned friend's skeleton.
Yes.
My submission is that that can be dealt with de bene esse, but I do say it is a new point, and I will say, I could say now if it would be better, that it is not consistent with the case put below and the evidence led below.
Right.
And I think my learned friend is content to proceed to bene esse. The court would have read the paragraph and so.
Yes. Yes. But on either of those passages, do you want us to excise them now, or shall we just proceed on the basis that we've read them, which we have?
Yes.
And what submissions the parties wish to make about them, we will of course consider in due course.
That is, the latter approach is what I am proposing given where we are, and I will just make the point that they are new when I get there.
Yes, of course, yes. Dr. Bowes, is there anything you want to say on the procedural point?
No, my Lord, if I can assist on this, para 32, my learned friend was quite right. That was an application, it was refused, it wasn't renewed, we're not pursuing it, so no objection to that being ignored.
Right.
Para 35, however, we don't accept that that should be ignored, but we're content to deal with it in the fullness of the submissions if that's acceptable to the court.
Right, thank you very much. Right.
Well, then I'll turn to deal with my first substantive topic, and the court has a timetable which identifies
Yes.
that the first thing I propose to deal with this morning is delay.
Yes.
That's a point taken in the respondent's notice.
Yeah.
From my Lord's note, it's page 263 of the bundle, and it relates to three of the grounds. Ground 1, which is the failure to publish the 106, ground 3, which is apparent bias, and ground 4, which is the exclusion of Councillor Price. the point is addressed in the judgment below at paragraphs 46 to 59, and in my skeleton at paragraphs 7 to...
Sorry, 46 to...
46 to 59.
Yeah, and...
My skeleton 7 to 11.
Yeah, if I may say so, Mr. Streeton, you're going to have to go slightly more slowly if you want me to keep up with my typing.
I apologise, my lord, I will do so. My essential submissions on delay are that on the law, the judge was right for the reasons he gave. And on the facts, even if we take the respondent's approach, grounds 1 and 3 were obviously in time. So the only relevance is in relation to ground 4. Before I make those good, if I could just be clear, my submission is that there is a distinction between whether a claim has been brought in time and whether any legal error alleged is academic. And I propose to deal now with the question of timing and whether it's academic when I deal with the ground in substance.
Yes.
So in terms of delay on the law, it is, in my submission, well settled and has been for 20 years that the appropriate approach is that taken by the House of Lords in Burkitt. I know the court will be well familiar, but given the point is taken against me, I would like to turn it up. It's tab 2 of the authority, starting on page 11. My short submission is that this authority is proposition, or in this case is authority for the proposition that the time for challenging the decision runs from the date of grant, even if the illegality alleged relates to a prior resolution of the authority, which could itself have been challenged. And I say there is a pithy encapsulation of that.
Hold on. The time runs from the date of grant, even if
the illegality alleged relates to a prior resolution of the authority, which could itself have been challenged.
Thank you.
And I say there's a pithy encapsulation of that proposition in the judgment of Lord Slynn of Hadley at paragraph 5 on page 14 of the authorities. Well, it's the detailed reasoning in the judgment is to be found in the judgment of Lord Steyne, in particular at paragraphs 38 to 51, starting on page 23. And if I could perhaps make a series of submissions with reference to the paragraphs set out there. Firstly, my submission is that paragraph 38 makes clear that it does not follow from the fact that the claimant could have challenged a resolution that he cannot wait to challenge the grant. That's clear in particular from the last 3 lines of paragraph 38 at the top of page 24. And my submission is that the reason for that is then expanded upon in paragraph 39, namely that the ground for challenging the actual grant is that an unlawful act has taken place, and the fact that the element of unlawfulness was already foreseeable at earlier stages of the planning process does not detract from this natural and obvious meaning. I then rely on both paragraphs 39 and 42 for the proposition that a resolution may come to nothing for various reasons, and in the middle of paragraph 42, 4 lines down, the line beginning March of legal logic one then finds the sentence, in law the resolution is not a juristic act giving rise to rights and obligations. In my submission, that is obviously correct, and it is, as the court regards it, a contextual factor tending to support the fact that the resolution itself does not necessarily trigger the 3-month period. See also the last line of paragraph 42, or last 2 lines, which make clear that judicial review is a remedy of last resort. Again, relevant to that context. And then thirdly, I say that the House of Lords identified 3 public policy reasons for its approach to saying that time runs from the date of grant, regardless of whether the resolution was challenged. The first is set out at paragraph 45 of the judgment of Lord Stain, where the court makes clear that the context is a rule of court which may deprive citizens of a right to challenge an undoubted abuse of power, and which may involve community interests as well as individual rights, and that in those circumstances, entrusting judges with a broad discretion of retrospectively assessing when a complainant could have first reasonably brought their case to court is antithetical to the context. See that from the end of paragraph 45. The second point made in paragraph 46, that legal policy favours simplicity and certainty rather than complexity and uncertainty. That's a point developed from paragraph 46 through to paragraph 49, described in paragraph 49 as a recipe for sterile procedural complaints, with the procedural disputes and unjust results. That's at the end of the first paragraph at the top of page 28, last 4 or so lines. The point is that the procedural regime is one which should be certain and everyone should know where they stand. And the third public policy reason identified at paragraph 50 is that the bringing of a claim for judicial review is a burdensome task, which again is further context reinforcing the view that it is unreasonable to require an applicant to apply for judicial review when the resolution may never take effect, insofar as that would then be subject to uncertainty by retrospective judicial decision. And so for all those reasons, I say the court, paragraph 51, enunciated a clear legal principle, namely that time runs from the date when the grounds for the application first arose, which is a reference to the date when the planning permission was granted, i.e. the formal grant, not the resolution. My essential submission...
Does it matter that there were different resolutions here? The resolution that ultimately led to the grant of the planning permission was it April 2023, was the other one was 2 years earlier, July 2021?
My Lord, it doesn't matter for the purposes of timing, provided... So it doesn't matter for the purposes of timing, full stop, but I completely accept that if the error was cured and either became academic or the effect was that it was highly likely the outcome would not have been substantially different, then that would be a reason for refusing relief. And in my submission, taking that approach of leaving whether it's academic and whether section 31, 3C to D or 2A applies in their proper boxes, keeps the legal certainty intended by the House of Lords and preserves the court's procedural discretion and substantive discretion to deal with the issue where it doesn't make a difference to the outcome entirely in accordance with established principles. So essentially, my submission is timing has nothing to do with it. It's all about materiality, which go to a different test. Well, the case relied upon by Dr. Bowes is the case of Field, which is behind tab 26 of the authorities, starting on page 504. That case related to a challenge to a decision to make a neighbourhood development plan, and the court will see from paragraph 3 of the judgment on page 507 that there are specific statutory time limits curtailing challenges under section 61N of the Town and Country Planning Act. paragraph 2, the Supreme Court identifies 7 different steps and numbers them. Paragraph 3 identifies the statutory provisions for challenge. And then paragraph 4 explains the interrelationship between those. So subsection 2 is about step 5, subsection 3 is about step 6, subsection 1 is about the final step, step 7. And the ratio in this case in my submission is based on that specific statutory context, as one sees from paragraphs 41 and 55 of the judgment. If one looks in paragraph 41, about 4 lines down, there is no clear presumption how the balance should be struck in the context of the statutory regime under consideration here, which would offer any guidance regarding the interpretation of section 61N. And paragraph 43, this is not, first few lines, this is not a case where the court can choose between rival interpretations on the basis that one serves the court's own perception of promoting efficient administration and proportionate or timely litigation.
Sorry, where are you now?
So paragraph 43, first 3.5, 4 lines. It's page 516, my lord.
Yes, thank you. Yes?
So in my submission, this is a different case. This is a case all about how those statutory provisions work. At paragraph 40, on page 515, it does cite Burkitt. But there is no suggestion it's overruled. What there is, at the end of paragraph 40, is a reference to the decision of Lord Carnwath in Champion, where he said that the wait to the end approach might have to be revisited in view of the administrative disruption. Now, in my submission, if it has to be revisited, it will have to be revisited by the Supreme Court and not by this court. But it was not revisited in the Field case. The specific paragraph upon which my learned friend Dr. Bowes relies is paragraph 36. And Dr. Bowes relies upon the word contingent, which is in the middle of the 4th line of that paragraph.
Yes.
Now, my submission is, insofar as there is a reference to contingency there, that is not about timing. That is no more than a statement of the obvious, as discussed earlier. Namely that if the earlier illegality does not on the facts infect the decision challenged, then the decision challenged will be lawful. I mean, I absolutely accept that proposition, but that is not about timing in my submission.
But on the facts of the present case, suppose you'd never had the resolution in 2021. You did have a resolution in 2023, and you did have the formal grant of permission following that resolution. So is that something that could be said to distinguish these facts from those of Burkitt? Burkitt was the standard case. You have resolution followed by grant.
Yes.
Here we have that, as my lord said earlier, we have that in 2023. So isn't it a matter of history by the time you get to 2023? It's not legally linked. The grant of permission in 2023, or is it? Is that in any way legally linked to the resolution in 2021?
In my submission, it is, because in 2023, when they debate the issue and when they reach their resolution which results in the grant, members are advised, and I'll make this good when I come to ground 4, that that previous resolution is a material consideration for them to take into account.
Yeah, well, that's a factual link, but it seems to me at least arguable that it's not on all fours with Burkitt, where there was a legal link.
But my lord, if we go back to the policy reasons in Burkitt, they apply with equal force regardless of how many previous resolutions there were, because, I mean, frankly, as the facts of this case illustrate, my clients cannot know that the matter is going to go back to committee until time has expired, so they will entirely justifiably and in accordance with the public policy in Burkitt rely upon that principle, not challenge the resolution and wait for grant.
Yeah, you may be right. asking whether there is that point of distinction. It may not be legally significant, but it doesn't seem to me, at least, to be completely on all fours with the facts of Burkitt.
There is a point of factual distinction, but it doesn't make any legal difference.
Yes.
Because were one to take Mern and Friends' approach and say that we should have challenged the resolution, you would run headfirst into all of the public policy reasons articulated in Burkitt. Because the practical effect of that would be you have to challenge the resolution in circumstances where you don't know what is going to happen later.
I understand that. Can you just help me with this? Why wasn't there the formal grant of permission after the 2021 resolution?
My client sent a pre-action letter, and they suggested that it be returned to the committee, and I would accept that had there been a fresh consideration lawfully, which rendered academic all of my client's complaints, then not for timing reasons, but for practical reasons, that would have wiped clean the issue. I completely accept that the issue could have been rendered academic. It wasn't, because members were told that the previous decision was lawful, that they should take it into account, and because the councillor...
They were told it was a material. They were told that the officer thought there'd be no material change, and they were told that they could take it into account as a material consideration. But they then went on to say, but we're not limiting members at all in what they can or cannot do. So I don't think you should necessarily assume that the sentence in the email from whichever officer it was, that it's a material consideration, is a complete answer. You may find that we don't accept that. You need other answers as well, just in case.
Yes, my lord. And I mean, those other answers, I think, are to be found in the tenor of the debate when we get there, because it is quite clear that, frankly, members were very concerned, at least some members, I should say, some members were very concerned not to revisit it because they didn't want to go back into the quagmire. And the advice also was that that was a lawful decision previously taken.
But they did reconsider it, though. They had a third motion, I think, which was quite clearly that it would be reconsidered, and there was a minor alteration in the proportion of the affordable housing.
The affordable housing point was at that first meeting.
But it was again at the last meeting. But don't get bogged down by details. The fact of the matter is a motion was put at the April 2023 meeting to approve the planning application. And they were told that they could consider all the matters, not just the curbing.
Yes, and so my submission, and this is not in my submission a timing point, this is a materiality point. My submission will be that they took the previous resolution into account, and insofar as that infected their decision, they were having regard to an unlawful consideration. As I say, that is only relevant to my ground 4, and I'll just on the facts make that good with reference to grounds 1 and 3, if I may now.
Well, so it took what the resolution from July 2021 into account as the material consideration.
Yes.
And what's wrong with that? Because
if it was unlawful, then
we don't know, because it was never quashed. It's lawful until it's quashed.
No, but my point is that I have the right to challenge its legality before the court. I'm within time to do so, to ask the court.
I thought you're challenging the grant.
I am challenging the grant, but
not the resolution.
I'm challenging the grant, but the point that I make in reliance on Burkitt is that I can challenge the grant with reference to the illegality resulting in the previous resolution, and in my submission there is a factual continuum between the first resolution on the 27th of July 2021 and the final resolution in April 2023 because of the advice given. If they'd done it a different way and said, let's look at this completely afresh, leave it out of account, I'd be in a different position before this court.
Right, okay.
As I say, that relates to ground 4, because on grounds 1 and 3, I say there is no basis for saying I'm out of time. Ground 1 relates to the publication of the Section 106 agreement as required by Article 43. Now, in my submission, plainly that illegality only crystallises upon grant, because at any time prior to grant, the defendant could have published the 106 and given time for comment on it. So you can only know it has not been published prior to grant once the permission itself is granted. So I simply do not see how a timing point can be taken on ground 1.
And also, you would say the likelihood is that if it's an entered agreement, it's going to have been entered into after the resolution, because the point is you get the resolution saying the officers are authorised to enter it. So you know at some stage after the resolution, they're going to publish or prepare a draft.
Precisely, my lord. Otherwise, there wouldn't be heads of terms and authority to agree one, because there would already be an agreed one. So I say on the facts for ground 1, the timing point simply doesn't arise. Similarly, on ground 3, which is a challenge to the appearance of bias in relation to Councillor Brodie, Councillor Brodie continues to be involved up to and including the final resolution that results in grant, and the conduct relied upon, to some degree, post-dates the July 2021 meeting. So again, I simply don't see how there is any potential to distinguish Burkitt.
Well, you say to some extent, but presumably to some extent it does relate to his conduct up to and including the July 21 meeting.
Yes.
So
It's
to that extent, Dr. Bowes, I think, would say you're out of time.
But my submission would be, how is that possibly consistent with Burkitt?
Well, that's a different point.
Yes.
You've made your submission about that. Now you're on the point
Yeah.
that time doesn't relate to ground 3 anyway.
And my submission is, if the conduct is a continuum, the court cannot close its mind to what happened prior to a resolution simply because there was a resolution. It has to look at that conduct in the round, consistent with the authorities on bias, which I can do when I get there, which say there should be a close scrutiny of all of the facts, essentially. So, my lords, those are my submissions specifically on delay.
Thank you.
I turn to deal with ground of appeal 1, which is breach of Article 40 of the Development Management Procedure Order. My lords, for your note, it's in the judgment below, paragraphs 73 to 78, and in my skeleton, paragraphs 12 to 41. And I propose to deal with it under 3 essential heads. Firstly, the correct approach to breaches of Article 40 as a matter of law. Secondly, the application of the law to the facts of this case. And I propose to deal with the facts in some detail at that point to save time on ground 2. And then thirdly, in light of the law and the facts, to make my submissions as to why the judge below was wrong. So, on the first of those, my lords, the correct legal approach. There is no dispute that the respondent did not, as a matter of fact, comply with Article 40 by publishing either a draft or the final Section 106, and you can take that from judgment paragraph 73. So the question of law in my submission is, what are the consequences of that? And the approach to answering that question is, in my submission, to follow Singh and the line of authorities derived from it, namely to identify whether Parliament can fairly be taken to have intended invalidity to be the consequences of the breach in this case. And I take that proposition from paragraph 23 in Singh, which is Authorities tab 7, page 103.
Sorry, which tab?
So it's tab 7, page 103, paragraph 23.
Thank you.
In the judgment of Lord Stane.
Yes.
And it's described subsequently.
Sorry, which paragraph?
Paragraph 23, my lord.
Right.
Described subsequently by Lord Brown in paragraph 78 as being the ultimate question, with a reference back specifically to that paragraph. There has been a recent, and in my submission, useful summary of the analytical framework in Singh by the Supreme Court judgment of Lord Briggs and Lord Sales in a case called A1 Properties Sunderland, which is tab 30 of the authorities. it's in a private law landlord and tenant context.
So which tab is that?
So it's tab 30, my lord.
Thank you. Yes.
And the paragraph I wish to go to is on page 606. It's paragraph 61.
Right.
Which begins the point of adoption of the revised analytical framework in Singh. And in my submission, that is a useful encapsulation of the approach, namely to move away from a rigid category-based approach to evaluating the consequences of a failure to comply with the statutory procedural requirement, and instead to focus on 1, the purpose served by the requirement as assessed in light of a detailed analysis of the particular statute, and 2, the specific facts of the case, having regard to whether any and what prejudice might be caused, or whether any injustice might arise if the validity of the statutory process is ultimately affirmed, notwithstanding the breach. I say that that is the analytical approach this court should take to Article 40. With that in mind, my lord, I would like to start just briefly with Article 40 itself, which my Lord Lord Justice Lewis rightly identified did not make its way into the bundles.
I spent about half an hour on Friday trying to find it, so it would be helpful, but it doesn't matter. I got there on Friday and I got it now.
I do apologise. For me, it's tab A, page A1, so the very front of my authorities bundle. Subsection 2 imposes a duty on an authority to keep a register in 2 parts. Subsection 3 relates to applications not finally disposed of. You see that from the last 4 words of the preamble before A to D. And the particular duty with which we are concerned in this case is 3B, which is a duty to keep a copy, which may be photographic or in electronic form, of any planning obligation or Section 278 agreement. My lords, that's the highways agreement. Proposed or entered into, and I do stress that it's both, in connection with the application. And in my submission, the purpose of that is to allow public comment on the adequacy of the terms whilst they're being negotiated and following negotiation prior to grant.
Hold on, public comment on the adequacy of the terms.
Whilst they're being negotiated, so that's proposed, and following negotiation prior to grant, so that's entered into.
Right. Following negotiation, following agreement, but prior to grant.
Prior to grant, yes.
So they can say, well, I know you've agreed the Section 106 and it's binding now, or will it be binding, but you shouldn't grant planning permission nonetheless.
It would be a very foolish developer who entered into a binding Section 106 agreement before grant, in the sense that most Section 106 agreements have a clause which says this only takes effect if you get permission granted.
You can comment on the draft as it's being negotiated, and you can comment on the final agreement up until the point in which the decision of notice comes out.
Yes, and essentially you can say, as an objector, you should do more, you should do less, this doesn't achieve what you want it to, this does achieve what you want it to. And to make that good, I'd like to look in detail at 2 cases which concern breaches of Article 4.3b, both in the High Court. The first is the Mid-Counties case, and the second is Davies. Starting with Mid-Counties, which is tab 10. Starting on page 161, judgment of Mr. Justice Ousley, and I would like to take just a little time with this case, if I may. It concerned a challenge by one supermarket operator, Tesco, to the grant of, a Mid-Counties cooperative, to the grant of planning permission for another supermarket operator, Tesco. So an example of the store wars that took place during the early 2000s. And if we could start in the judgment, please, under the heading Consultation on the Section 106 Agreement on page 163, paragraph 83. Paragraph 84 refers to a circular then in force, and to be clear, that circular is no longer in force. It's been replaced by the planning practice guidance, which I've checked is not in like terms. It doesn't have an equivalent provision. Paragraph 85, if we could just note in the fourth line, fourth word, the sentence beginning, the heads of terms were set out in the committee report and in rather more detail in the addendum report. That will become some degree relevant because the heads of terms were not set out at a high level in my submission. They were set out in detail.
Sorry, I beg your pardon. I'm just going back to 84 again.
Yes.
So this is based not on the failure to publish, but an adequate opportunity for consultation and comment, contrary to the obligations of fairness and the legitimate expectation created by the ODPM circular. So is he directly dealing with the obligations generated by Article 40?
He deals with both, my lord. And the reason for that, we see from paragraph 85, is that the final, it's the last couple of lines, goes over the page to 164, that the final draft was published, but just for a very short period, for 3 clear working days before the permission was actually granted. And we'll come to see that that is relied upon in the context of prejudice by Mr. Justice Ousley. What is, in my submission, directly relevant in this case? Well, in fact, before I get there, I apologise. Paragraph 86, you will see that the sum was set out in that case. So you see it referred to a payment of 50,000 for junction improvements. So the sum was already there. Paragraph 87 is directly on point, because that does deal with Article 43, as well as with the language of the circular. And if one looks at the last 4 lines, the line starting on its terms, it's the sentence, the language of the circular, which treats a draft as a proposed Section 106 agreement, is a correct reflection of the statutory language and its purpose. So what Mr. Justice Ousley is saying there is that the circular correctly encapsulates the purpose of Article 40. The purposes of interpretation of the statute, such as the circular provides, enables the statutory language and objectives to be satisfied. So that is on the construction of Article 40.
It's on the construction of proposed, yes.
If we could then look at paragraph 90, perhaps worth noting 89 en route. Paragraph 89, last 4 lines, Mr. Justice Ousley understands, no doubt from practice, how parties engaged in negotiations may find it irritating to receive comments from an objector on the 106 agreement which they are endeavouring to negotiate, but says that doesn't absolve the Council from its obligations and is not in the spirit with which its statutory obligation should be approached. So that, again, in my submission, is consistent with my construction of Article 40, as is paragraph 90, which makes the point that a Section 106 agreement is not a private agreement any more than conditions are exclusively for private negotiation. And in my submission, that must be right, because the purpose of the planning obligation, where a grant is subject to it, is to make the development acceptable, which is a matter of public interest. Then paragraph 91, my lords, deals with what is required to comply with the statutory obligation. And Mr. Justice Ousley says that compliance with the statutory obligation would have required not just the heads of terms, but at least one draft, as well as the final version of the Section 106, to be placed on the register as a means of making it publicly available in my judgment, the statutory requirements of the GPDO, as it then was, now the DMPO, were not met. In my submission, that is entirely consonant with my construction, and that clearly is on the construction of the instrument, not the circular. What Mr. Justice Ousley then does is goes on to consider the question of procedural unfairness, and he starts at paragraph 94, rightly in my submission identifying that that is bound up with the question of whether there was actual prejudice.
But you've got to look at 93. He's not now dealing with what are the consequences of the breach, simpliciter of Article 40. He's now moved on to a different chapter in the textbook, headed legitimate expectation of proper consultation engendered by the circular and the Council's own correspondent.
Yes, my lord. So at paragraphs 96 to 98, he cycles back to deal with both. So he says, where you're dealing, so this is 96, he says, where you're dealing with legitimate expectation, i.e. the non-mandatory procedure, then the burden is on the claimant. And then at paragraph 98, he records a submission of Mr. Holgate, as he then was, that it's for the defendant to establish why relief should not be granted in respect of unlawfulness in relation to the GPDO. And then paragraph 99, his conclusion refers back in my submission to both of them, and he says, I'm satisfied that there has been no prejudice. So I quite agree with my lord that analytically he is at this point moving into legitimate expectation, but he then cycles back.
Well, you say that, but I have a slightly different concern from my lord, which is that at paragraph 98, he seems to be moving on to remedial discretion.
Yes.
Which isn't Singh.
Yeah.
No, so he does not refer to Singh.
No.
And in my submission, it would be helpful for this court to clarify the approach that should be taken in these cases with reference to Singh, which I don't think has been directly applied in the context of Article 40 when the court has considered it. My submission is that it is the correct approach to take. And I say that Mr. Justice Ousley's approach, whilst it isn't clearly a Singh application, is in substance consonant with Singh, because what he looks at are the consequences of a breach in terms of prejudice. He deals with that as a matter of discretion, but it comes to the same in my submission.
Well, they are analytically different, and it seems there are two problems now. If we're trying to work out what Article 40 requires, Article 40, Mr. Justice Ousley wasn't dealing with that. He was dealing with something quite different. The last chapter of the textbook, discretion.
Yeah.
Well, in my submission, he does deal with what Article 40 requires, and paragraph 91 is a clear encapsulation of that.
Yes, but it doesn't deal with the question that we're dealing with, is what are the consequences?
No, because he skips that and moves to the last chapter of the textbook, as my lord puts it.
Well, he does two things. Firstly, he goes and reads a different chapter. He reads the legitimate expectation chapter, and when he comes back, which is the only time he comes back to Article 40, as my lord says, he's dealing with it in terms of if there is a breach, should it be quashed as a matter of discretion? Whereas we're on something different, which is analysing in legal terms whether or not there is illegality because of the breach.
Yeah, yes, my lord, that is correct. Yes. And I am not aware of authority directly on the approach to be taken.
Yeah, and we're not bound by a first instance decision. We are bound by two decisions. One, the House of Lords in Singh, and two, the Supreme Court in A1 Properties.
Yes.
And analytically, at least to my mind, what they're both saying is that it's nothing to do with the court's remedial discretion. It's everything to do with the correct statutory construction of the provision being considered. And the ultimate question is, did Parliament intend breach of that provision to result in the invalidity of the decision?
Yes, my submission to you is that that is the correct analytical approach.
Well, that's fine, Mr. Streeton, but at the moment I'm not seeing why you're citing this case.
Well, firstly because it is one of the two reported cases on the point, and secondly because what it does deal with is the purpose of Article 43B, and that, in my submission, is relevant, and I will also deal with that at a higher level with reference to the case of Mosley. That's why I put that in. But on the minutiae, I looked at the construction of the legislation and I say, insofar as this decision is relevant, it assists in understanding what the purposes of Article 40 are, I'm not suggesting it's a complete answer to the analytical framework.
Right. Anything else in this judgment?
I think it is only right that I note for the court the way in which Mr. Justice Ouseley deals with prejudice, which is from paragraph 99 and following. Now, this is obviously in the context of residual discretion, and I accept that, but prejudice is a relevant question when we use the Singh analysis. And he finds in this case no prejudice at all for 5 reasons set out at paragraphs 100 to 104.
Yeah.
Firstly, paragraph 100, there was no change to the heads of terms, which, as we've already seen, included the specific sum of money. Secondly, and in light of that, the complaints could only go to the detailed drafting. Thirdly, and I take the third and the fourth together, Mid-Counties had remained an objector and had lawyers and consultants already familiar with the principles of the Section 106, aware of the objections, and so in that case, and this is the point I said I'd come back to, last 2.5 lines, it's the third line forwards from the end, albeit that it only had a short time in which to deal with it, i.e. it did have the 106 and the opportunity to comment was just a very short period of time. It did nothing, bearing in mind, we are talking about Co-op versus Tesco, there were lawyers with their pens to the ready. Fifthly, and crucially, paragraph 104, no evidence at all that Mid-Counties would have said anything on the detail of the draft, let alone any evidence as to what it would have said, notwithstanding all of the evidence before the court. And I just note, paragraph 115 on page 169, Mr. Justice Ouseley distinguishes the position in terms of representations from what he calls the unattractive point, which sometimes arises in relation to unfairness or discretion, which is that the answers in consultation would have made no difference to the counsel's thinking. So that's not what he's saying. And then his overall conclusion of 116 is that there was no prejudice and he does not grant relief in that case.
Now, although we have said that analytically this is distinct from a true Singh point, do you accept that in the present case, if we reach this stage of the analysis, that we would have a residual discretion at the remedy stage, and if we concluded, as Mr. Justice Ouseley did in this case, that there was no prejudice, that we would be entitled to refuse relief?
Absolutely. Yeah. I mean, to be clear, my case is that there was prejudice. And I would completely accept that in the absence of prejudice, one, in the context of Singh, it's unlikely Parliament intended for there to be a vitiating effect where there's a breach which causes no prejudice, and two, even if Parliament did intend that effect, I would fail on discretion and on section 31(2)(a) as well. So I'm not suggesting prejudice is anything but critical to my case.
Right.
The other case that I wanted briefly to look at on Article 40, and again it does not take in my submission a true Singh approach, is the case of Davies and Oxford behind tab 28, which is a first instance decision of Mr. Justice Julian Knowles. Helpfully the page numbers are obscured by the photocopy. So, my lords, this case concerned a challenge to grants of permission for residential development in Oxford on 2 grounds. The second ground was a breach of Article 43b. And again, if we could just look on the facts at paragraph 19, which I can tell you from using the electronic bundles, page 556, but I doubt that's very helpful. It's the report, page 161. You will see that the first officer's report set out in detail the contributions and the purposes of those contributions. So you see there's a series of figures and an identification as to what those figures are to be used for. And then report page 165 and following, paragraphs 38 of the judgment deal with the supplemental report referred to as OR2. And again, if one looks, for example, at 43 to 44, you will see that that officer's report dealt with the specific contributions in terms and gave sums of money. And if we then go report page 168, paragraph 52 of the judgment, you'll see that those contributions were ultimately the same as what went into the 106. So it's the second sentence, the definitions include the purpose to which the contributions were aligning with the contributions discussed in R2. On the facts, the final point I want to identify, the relevance of which will become apparent, is over page 169 at 58 to 61, and it's the evidence of Mr. Barbosa. His paragraph 6 exerted at paragraph 60 of the judgment makes clear that the council's position was that it simply could not go further in the 106 and require the delivery of the works for which the contributions were sought, because capital spend has to go through the county council's capital programme and capital spending protocol. Paragraph.
What's the relevance of that? I don't understand that.
It will become relevant when we look at the approach to relief in this case.
This is the district council, isn't it? Yes, it's the city council, not the county council. Yeah.
Yes, but you will see that what the court ultimately says in that case, the reason why it exercises its residual discretion is it says there could have been no different outcome because of what was said in that paragraph, and that's why I went there now.
Right.
Before I come to the ratio, I just identify paragraph 66 on page 170, which deals with Article 43B, and very short. The point made is that Article 43B, in brief, requires that any draft planning obligation must be placed on the planning register so that parties can comment upon it. And he says an example of an obligation is a Section 106 agreement. It could be a Section 106 unilateral undertaking. That's the point. Then 67, he cites in detail mid-counties, and we've been through all of the paragraphs that he cites. And his substantive judgment on this issue is at paragraph 129 and following, which starts on report page 181. And in this case, as the court will see from 131, he concludes there was substantive compliance with the requirements of Article 43B. Now that is a Senagi type analysis, although it's not analysed in the true Senagi sense of my submission. And in any event, no prejudice. And in reaching that conclusion, he makes the following points. Firstly, at paragraph 132, the substance of the agreements as contained in the heads of terms were placed on the register through the officer's reports. And as I said, that needs to be understood in the context of what those reports actually showed in this case, namely specific sums of money for specific purposes. I
appreciate the officer's report here didn't have the sums of money, so I'm not asking about that. I'm about to ask a different question. Was the officer's report itself including the heads of terms so far as they went on the register?
Yes. Yeah, not in dispute. I think I would struggle on prejudice in any event, given the debate at the committee meeting.
Even if it wasn't on the register, everybody, including your clients, knew jolly well what was in the report.
Yeah, exactly. So
your point is it didn't include the figures.
Yeah, the figures is really what matters. And how the figures were good, but really it's the figures. Secondly, paragraph 133, there's no evidence that the claimant in that case checked the planning register. That's different from this case.
So is there evidence that they checked the planning register?
There is. Firstly, what we have before this court is the memorandum of the I can go,
you're going to come
I
back
can go
to
there now.
that. Okay.
And I don't believe it's in dispute because there was a witness statement below, but I don't think it's in the bundle for this court. But there was direct evidence on it.
Right, okay. So you say that the planning, I understand your letters and your emails and resolutions, but as a different matter, you say that there was evidence that the planning register was checked.
Yes, for absolute certain, there was witness evidence which said that below. What we have before this court is the memorandum of the company, which records...
We've got the letter of the 22nd of March, the memorandum or the resolution of the company, and the witness statement of Miss Rahman
Yes.
later, but none of that says I checked the planning register, which is the question that I was asking.
Well, the memorandum of the company says it's not on the register, and the only way you could know it is if you check the register.
Right, okay.
That's my point.
Right, okay.
But below there was evidence which said it was being directly checked, and if Milan Grant doesn't agree, then tend to be corrected on that.
Right.
But so in this, for both of those reasons, I would say we are not on all fours with paragraph 133. Thirdly, the position taken at paragraph 133 is that it would have made no difference, and we see that one as a result of what's said at paragraph 34, namely that if they had asked for it, it would have been supplied, and so the council's position in that case was if you asked, you would have got it, and two, on the specific facts, and this is paragraphs 135 to 139, the court finds that in light of the evidence of Mr. Barbosa, it could not have made a difference. And then you see that in particular paragraph 137, last 3 lines, for the reasons given by Mr. Barbosa, which I set out earlier. And that's why I showed the court that, because it was specific to the facts of that case.
Was the County Council the Highways Authority in this?
Yes, it was. In Oxford, Oxford County Council is the Highways Authority, so it's not a unitary authority.
No.
And it was an interested party to the proceedings, I believe. Yes, it was. Now, my lords, in my submission, neither of those cases directly applies Senegi, but Davis in particular is an essential application of the approach in Senegi, and mid-counties at least has analytical similarities. Both of them recognise that the purpose of the statutory requirement under Article 40 is to enable members of the public to comment on the Section 106 planning obligation by way of consultation.
No, ability to comment. Where does the word consultation come in?
Mr. Justice Ousley, I think, does use the word consultation.
Because he was dealing with the circular. We went through that. He was dealing with the circular. If you're looking at the statute, all the statute says is publish it before it's concluded. Mr. Justice Julian Knowles said the purpose must be to allow them to comment. That's slightly different from what we would expect consultation to be. You'd expect a statutory duty to consult, and that has different requirements again.
Mr. Justice Ousley, I think, does say that the purposes as enunciated in the circular...
Yes, exactly.
But he says that those are... let me just find the word because I don't want to misquote it. A correct reflection of the statutory language and its purposive. A purposive interpretation of the statute as the circular provides enables the language and objectives to be satisfied. That's paragraph 87 of the judgment.
But that's dealing with the question, that's why we raised that. He was asking or dealing with a submission that it was only the executed agreement that had to be on the register. And you say, no, that's not right. And he interprets the order to be wider than that. But that is not to say that he is finding that the order imposes a statutory duty to consult. He wasn't dealing with that there at 87, was he? Or was he?
In my submission, what he is dealing with includes the purpose of the statutory language.
But why?
I accept that it's because of the point being made in that case.
Yeah.
Namely that we only had the concluded agreement.
Yeah.
But that doesn't take away from the fact that that is the purpose of the statutory language.
And I'm sorry, I'm looking at 87, and with the best will in the world, I can't see that this is anything more than the language of the circular, which treats the draft as a proposed agreement, is a correct reflection of the statutory language and its purpose, i.e. that the purpose of the development order is to cover not only executed, but also draft agreements. I just don't at the moment see where you're getting your submission from, that Mr. Justice Ousley said that a purpose of Article 40 was to enable a consultation, that it was imposing a duty of consultation. That's where I'm stuck at the moment.
Well, I mean, it's a different paragraph, but one way in which he characterises the prejudice point of paragraph 101 is about complaints in relation to consultation and negotiation, and it may be that that's loose language.
Well, the problem is we've already gone through this, and there are three things. There's the obligation in the order, there's the circular, and there was the reference to correspondence. And certainly the latter two was seen as imposing an obligation of consultation. And all I'm asking is, because you said the court say ability to comment for the purposes of consultation, and I can understand the ability to comment, and it may not be a big point. I'm at the moment not convinced that either of those two cases say consultation in the way that we would normally understand that in a public law court.
No, I would accept that they do not put it in those terms, certainly not squarely. But in my submission, the purpose of enabling comment is to enable consultation with a small c. Now, I accept that what consultation requires, what fairness requires by way of statutory consultation is context specific, and so the statutory language is going to be relevant to that. But the submission that I propose to make now is that the purposes underlying a statutory duty to consult are relevant, whether or not one characterises it as a formal consultation process or the opportunity to comment, because fundamentally the purpose is to enable members of the public to have their say. And
duty to consult, you must provide an early opportunity, a draft, you must provide sufficient information, you must give them sufficient time and so on. There's the four gunning principles.
Yes.
That's what you're saying applies here.
Yes, I am saying that applies. Obviously, it's context specific, the gunning principles, and perhaps if we turn up Moseley now,
just before you move on, I'm not sure why you're making this submission. I'm not sure that you need it.
No.
All you need, but correct me if I'm wrong, is to make the submission that there is legislation which requires something to be published on a public register. And the purpose of that legislation is to allow members of the public to comment.
Yes, my lord.
That's all you need, isn't it?
Yeah, I mean, yes, that is correct.
Well, why do you need gunning?
Well, because, for example, I basically said that it corresponds to what Article 40 requires, because if you do not have the detail of the 106 agreement, you don't have sufficient information to make a comment on it. If it's published the day before, and this perhaps is the point that was being made in Midlands, if it's published the day before, you do not have sufficient time to read the 200-page agreement.
But if it's not there at all, then why does any of this
No,
matter?
it doesn't. I don't need it, is the short answer.
Okay, now you wanted to show us Moseley.
Yes, I mean, simply because I say that the purposes of consultation are consonant with the purposes of Article 40, and those purposes...
Sorry, where is Moseley?
Tab 33 of the authority, so it was added.
Yeah, and where do you want us to go?
Paragraph 24.
24.
Yes.
Thank you.
And what Lord Wilson does here is draw on Osborne and the Parole Board and the duty of procedural fairness to identify the purposes in the different context of statutory consultation of what.
What are we talking about here? Is there a statutory duty in this case which sets out what the obligation is, and if so, should we not look at that? Or are we dealing with another chapter in the textbook as we go through it sequentially called procedural fairness? Now, what are we dealing with in 24?
Well, in Moseley, we were dealing with a statutory duty to consult, I believe.
So where's that duty then? Because we'd have to compare that, would it be, with Article 40? See how similar they are. Because you're assuming they're the same. But the starting point is to read the words to see if they're the same.
Well, I was not assuming that. I was assuming only that the high-level point made in paragraph 24 about providing better decision-making and public engagement is relevant to what the purpose is behind Article 40. It's not more complicated than that.
Right. Okay.
So the short point I wanted to make was, if you don't allow people to comment upon the 106, then that is liable to result in less good decision making.
I'm not sure we need statement from the Supreme Court to tell us that.
No, my lord, I accept that.
All right.
The final 2 points I was going to look at, but we probably don't entirely need authority for the proposition, relate to prejudice in the context of statutory procedural duties. The first case is the Coburn Studios case, which is Authorities tab 18. This relates to a different statutory duty, but under the under the Local Government Act and the Development Management Procedure Order.
What tab is that?
It's tab 18, my lord, starting on page 360.
Right.
And the paragraphs I wanted to deal with relate to material prejudice on 389.
Right.
And the first point I wanted to make is that prejudice may be not to the specific claimant, but to the public generally. See paragraphs 115 to 116.
But this is a case where the officer's report was, I think, described as opaque, containing contradictory information and so on. You can't just take as can you to broad statement that if people have suffered, the public might have suffered, without looking at whether or not or what the prejudice was. It's a bit misleading, isn't it, to not show us the facts?
Well, I'm not deliberately not showing you the facts, my lord, and it is an application of a general principle derived from other cases, Wilson and Walton, which are in a very different context themselves. But I completely accept that the facts were very different.
Yes. And they were that you couldn't tell from the report what was happening from recollection in this case.
So that the facts were that there was a late change to the scheme that was not publicised until the day of the committee meeting. And so that's why part of this judgment deals with the Wheatcroft test. And this is a case which identified that there are two limbs to that. Firstly, whether it's different in substance, and secondly, whether it was procedurally fair in any event to make the change.
So there's a late change to the scheme which wasn't publicised until the date of the meeting.
Yes.
And then were there other things, or am I misremembering?
No, my lord, I think you are correctly remembering that the officer's report itself had photographs that there would have been a wish to comment on and was unclear. Paragraph 113, before we get into the section I wanted to go to. The point being made by the claimant in that case was that he would have wanted to make detailed further comments about a number of matters which he considered made the damage to the area greater than under the initial application. So that's a result of the amendments to the scheme. What he's saying is, if I'd had time to think about the amendments, I would have wanted to say things that I didn't have time to say because you only told me late.
So this is all about a change in the nature of the proposals then?
That was a fundamental point in this case. And the point I wanted to draw from it was the first point I just made with reference to 115 to 116. It's not just necessarily prejudice to the claimant, it might be prejudice to the public more generally. And secondly, the caution urged on the court, paragraphs 121. And following with reference to the well-known decision in Ex parte Brent.
And again, what was the obligation here? that was breached, or what are we talking about?
So there
We're
was
just taking sentences at the moment and saying, look, that's a good principle, but a court judgment proceeds on facts and decides principle, and I haven't got a clear view yet what this decided or what the duty was or anything like that.
yes, well, so the breaches in this case related to the late alteration, as I identified, and
That was a breach of what?
so that was found, I think, to be a breach of the Development Management Procedure Order because you're required to publicise the application.
Right, so it's the same sort of thing that Article 40 was breached because they made a late change the day before or the day of the meeting.
So it's not Article 40,
Well, okay.
but yes.
That's what I'm asking, what is it?
So in Hoban Studios, the key point was that a late change was made to the scheme.
Yeah, and the first question was, what is the duty that applies them to publish
Yes,
the
and
scheme?
that was under the Development Management Procedure Order. In particular, I think it's paragraph 10, Article 7,
Oh, look at that.
page 365. And there's a series of duties identified in that paragraph and following.
There would be to include the particulars specified and to be accompanied by a plan which identifies the land, yeah. Right. And what happened here then was what? That the day before or the day of the meeting, particulars were published which were very different. Is that what happened?
Yes, so the change was made some weeks before. But not publicised, and then people turned up to the committee meeting and were faced with something different from what they were expecting.
So all the comments about the prejudice there have to be seen in that context.
They do, and in the context of paragraph 17, which I think would equally apply to Article 40 of the Development Management Procedure Order, which refers to Section 65 of the Town and Country Planning Act, namely that a local planning authority shall not entertain an application for permission unless the requirements imposed by virtue of the section have been satisfied. So there was a particular statutory.
Yeah. So that's a paragraph 12, yeah.
Set 17 was what I was referring to.
No, 17.
But it's simply a reference back to that.
Right, so you had a requirement there, which was shan't entertain an application for planning permission. The requirements weren't satisfied and they knew they weren't satisfied, so on the meeting, people were faced with a different development from the one they turned up to
Yes.
deal with.
Yes.
And that was prejudice to them.
Yes. But the point I was seeking to make was the caution with which the court generally approaches submissions that representations which have not been heard would inevitably have made no difference. And that's paragraph 121 of the judgment, which cites ex parte Brent. And then paragraph 122, which makes clear that that caution is reinforced by the fact that matters of planning judgment are essentially ones for the democratically elected planning authority, and it is not for the court, generally speaking, to anticipate what the outcome would be if a planning authority had regard to representations it's not considered. And so the point that I wanted to make, which I accept is at a high level of generality, is that where you are dealing with matters of planning judgment, particular caution applies to saying representations wouldn't have made a difference.
But the deputy judge in this case, at the top of page 390 of the bundle, paragraphs 117 and 118, does in fact conclude, I think, on the facts of that case, that that there hasn't been substantial prejudice to the claimant, is that right?
No, my lord. He expresses that as would not have, but he ultimately finds that they did.
All right. Why is he using the phrase substantially prejudiced? Is that because there was a specific legislative regime?
No.
Obviously, I'm aware that in some planning legislation, that phrase specifically appears.
Yes, it's not. So this wasn't a Section 288 challenge.
No.
And as far as I'm aware, that phrase did not appear in the relevant legislation.
Okay. That's very helpful. The other thing that slightly concerns me about many of these judgments that we're seeing is that people often appear to start using the language which, to my mind, is most relevant at the remedial discretion stage. So questions like, would it have, is it inevitable it would have made no difference? Sounds like simplex to me. And it's a different test from the test which we've had now since the reforms in 2015. And I'm just slightly worried that we are not keeping conceptual clarity, because at this stage at least, to my mind, when we're addressing your ground one on this appeal, we're not dealing with remedial discretion, are we?
No, we're not. But there is in my submission analytical overlap between the question of prejudice for the purposes of synergy and the question of prejudice for the purposes of discretion.
Yeah, you may be right. There may be an analytical overlap, or it may just be analytical confusion, which has crept into the authorities.
And you have to read paragraph 1, 2, 3. You can't just take sentences out that say, apple pie is good, my client favours apple pie, therefore I'm good. And 1, 2, 3, there's an example of the prejudice there. There were issues about residential units and issues about the loss of the affordable housing. Members might have decided that the mix of uses proposed should have been different. So I'm not saying that you can't use this case for what you're saying. All I'm saying is it's much more helpful not to take sentences out of context, but to look at the duty, look at the facts, and then ask whether or not this really does help very much on synergy and or on material prejudice for fairness and or section 31.2c or section 31.2a.
I apologise. I think I was just trying to go too quickly.
Yeah.
That's the honest answer.
No, that's fine, Mr. Streeton.
So, my lord, I propose to apply the synergy principles at this point.
Right.
And I will deal with the facts in some detail, as I said, so that I can cover off grounds 1 and 2 together. But my submission will be that the Council did not comply in substance with the statutory duty under Article 43b, because it did not give people an opportunity to comment upon the substance of the obligations. And when we look at the heads of terms, essentially they did not substantially enable people to comment. Secondly, that the appellant and or members of the public whose interest the appellant represents, because its shareholder is the Residents' Association, were materially prejudiced because they requested the 106 and were checking the planning register for it, and because there were representations they would have wished to make.
Hold on. When were materially prejudiced, A, because they were requesting the section 106.
Yeah.
B, because they were checking the register.
And C, because there were representations they would have wished to make.
And do you need to have all three?
No, in my submission, 1 is enough.
Okay.
But obviously, a fortiori, if I have all 3, the prejudice is greater and Parliament is less likely to have expected.
Yeah. Okay.
So, well, to deal with the facts, and as I say, if I could address these in detail, and then take rounds 1 and 2 on submissions.
Yes.
The first place I'd like to go is the transport assessment, which is in the supplementary bundle, tab 12, page 65.2. This is the developer's document, and what you should have is table 5.38, which is a helpful summary of the findings in the transport assessment, and what matters are the red squares, and those relate to 2 junctions which are identified in the left-hand column, Westridge Cross and Preston Road / Smallbrook Lane. And the point that I wish to make is that in the basin committed without penny feathers and the basin committed with penny feathers or Smallbrook Lane, the junction is over capacity, i.e. it's red, and we see what red means from the bottom of 65.1. Red signifies the junction would operate over capacity.
Yeah, which is why you have the next boxes, which seem to have different mitigating proposals. Because if you have the mitigating proposals, for example, I don't know what box 4.3 is, Westridge Cross proposed mitigation, drawing 5622, looks awfully like a planning reference, but we're just given one page of this document, and that seems to be saying if you have that proposed mitigation, it'll be 89.6, which is okay.
Yes, so the point is that the mitigation is necessary.
Yeah.
And for Westridge Cross, base plus committed plus proposed without penny feathers, you need the mitigation.
Yeah.
And it is as simple as that. In my submission, what I'd like to do is look at the way that the statutory consultee, the Highway Authority, then dealt with it.
So have we moved off ground one now?
No, my lord.
Okay.
I'd like to deal with the facts compendiously for grounds 1 and 2, and then come back to make my submissions on ground 1. But the reason I will say this is relevant to ground 1 is when I look at prejudice, because I say it is important to understand the nature of the issue and the mitigation, the money for which is required when one considers the question of prejudice.
Right.
So the next document I wish to go to is the statutory consultation responses of the Highways Authority, which are behind the next tab, tab 13. And these are statutory responses pursuant to Article 18 and Schedule 4 of the Development Management Procedure Order. The first one is the 4th of the 9th, 2020, starting on page 66. And that deals with capacity and traffic impact, starting on page 80.
Yes.
And my lords will see from the table it identifies numbers of departures and arrivals. And then over the page 81, is a summary of what was in the transport assessment and the conclusions of the Highway Authority in relation to it. So the second paragraph, first full paragraph on the page, starting paragraphs 5.36 to 55, summarise the evaluation of the same junctions with all committed and consented developments. This identified all junctions except Smallbrook Lane and Great Preston Road will continue to operate within capacity. It being acknowledged that the Penny Feathers development includes significant mitigation measures for both Westridge Cross and Smallbrook. So the point being made there is if you have Penny Feathers, you will get mitigation, and therefore you will not be over capacity. And then 2 paragraphs down, 5.69 to 9.5, deals again with the data subject to the inclusion of the mitigation measures as proposed. And then you get, however, 5.96 to 100, identify without the inclusion of the Penny Feathers Westridge Cross junction remodelling works, the junction, in addition to the Smallbrook Lane junction, would exceed operational capacity in the PMP with the addition of the development traffic. So that's what we saw illustrated.
So far, all we know is junction 4 and 5 will have overcapacity and will need mitigation. And this is saying what you've just shown us, that the transport assessment shows overcapacity at junctions 4 and 5.
Yes, and then the next paragraph deals with the approach to addressing those. And I perhaps might just ask my lords to read that paragraph to the end on page 82.
Yep, and that makes the point well before the first planning application committee that you need this mitigation, and some of it's on third party land, which happens to be Penny Feathers, yes.
Yeah. There's then a subsequent consultation response from December 2022.
Yeah.
So that starts over the page on page 83, and it's the last page behind this tab, page 93.
Yeah,
And if I could just ask the court to read the final 3 substantive paragraphs, starting as a result, the application is provided to the end.
Yeah.
And so what's said there is that we will making a recommendation for refusal on this basis, and then the penultimate paragraph. However, a question is now raised in respect of the sustainability of a recommendation for refusal on the grounds of the attributable development-based traffic impact on these junctions, when considering the decision made by the LPA and Development Control Committee in relation to 2 applications, those related to Nicholson Road and the mitigation measures that are proposed. This office seeks the opinion of the LPA, and as I understand it, what that is saying is you didn't secure the mitigation there, so is this capable of being a reason for refusal? That's a question for the planning authority to make a judgment.
Yeah.
And then it says, furthermore, this application includes indicative junction improvement works. The applicant proposes a financial contribution towards junction improvement works, mindful that the local authority is currently in the process of reviewing the junctions in order to bring forward a network of improvements. So that was the position as at their consultation response. They were mindful that that was underway. The issue was controversial prior to the grant of consent.
So can I just check one thing? You've just told us, because we don't know, we're not the planning committee, that the one that had been granted permission without mitigation.
I think without securing full mitigation, I think that is the point.
Ah. What's that mean without securing mitigation? Was it in the proposal, or was it the same point that you're hinting at?
I think it's
third-party land, or it's hard to know what to make of this.
Yes, my lord.
What do you derive from these 3 paragraphs is what I don't know.
What I derive from these 3 paragraphs is that the Highways Authority were raising a concern that they had previously raised a reason for refusal, and that they were accepting that it was a matter of judgment whether it continued to justify refusal.
Yeah.
That is what I take from these. It being said that they are in the context of reviewing the junctions and the improvements at the time.
Yeah. Okay.
Well, my submission is that the point was controversial prior to the grant of consent, in addition to what the Highways Authority was saying.
When you say the point was controversial, can you just be clear what point?
The importance of securing highways mitigation given the potential significant adverse impact upon the highways network.
Yeah.
And there are 3 examples of members of the public or their representatives commenting on it. So there's the ward councillor, Councillor Lilly. It's the next tab, tab 14, pages 94 to 95, and it's the last paragraph on 94 and over the page to 95. It's the first 3 paragraphs on 94.
Yeah.
Next tab, tab 15, there's also an objection from Penny Feathers itself.
Yeah.
And identify, page 98, the way forward. And what they were saying.
This is July 2021.
Yes.
Yeah.
And then November 2021. The email from...
So what is this actually saying? The first page just says it seems that there was going to be a consultation document or consultant's document, and that hasn't been published. Is that all it's saying?
No. So the first thing it says on page 97 is You've referred to a report which we haven't seen and we should see it. The second thing it says under the heading planning guidance is that...
Sorry, where is that now? I mean, my concern is that despite objections to the Houses, the committee report, 6150, relies on a recently commissioned consultant's report. Is that what you're saying is the first thing it's saying?
Yes, I think so. So the heading is reliance on, so page 97, reliance on background paper which legally needs to be publicly available.
So that's a complaint about a consultant's document about revealing the junction system as a whole.
Yes.
Right, so that's not this case then?
No.
Yeah.
Then there's a complaint about requiring the consent of third-party land.
Yeah.
And planning and so this is page 98.2, and this is this case.
Yeah.
Planning contribution should not be simply collected for a scheme unless there's a clear scheme in place, which of course requires public consultation. And then there's a proposal in terms of a way forward.
So where are you reading from under the... Yes.
So planning guidance, last sentence, point 2. Planning contribution should not.
So it's point 2, yes?
So what that says is, if you're going to say you're going to mitigate and work out what a contribution you're going to achieve under 106 is, you need to know what you're securing. So contribution.
If collecting for a scheme, you need to know what the scheme is.
Yeah, that's what they're saying. That's their
view.
And then the way forward emphasises the importance of having highway infrastructure in place in a timely manner.
Yep.
Points out that paying contributions to the council puts the burden on them, which normally would be on the developer. Refers to the report which is still being finalised. And then gives the council options. So paragraph 3, defer. Paragraph 4, grant subject to a grampian condition, i.e. no development until. And paragraph 5, refuse. So that's what they are saying.
Yeah.
In terms of public interest, not in the sense of the public interest, but public concern, in the question of highways mitigation works, the final document that I wanted to go to behind tab 10, pages 49 to 51. Emails from Christina Nicholson, and it's page 50 to 51. So 51 is the email starting Dear Piercy Wilcox. And page 51 of the bundle.
Yeah.
And in the second paragraph, she's concerned that Island Roads will carry out the public highways works for Nicholson Road, Pennyfeathers and Westacre Park at the council's expense and will later claim the money back.
Yeah.
And then there's a response from the council on page 50.
Well, you see the council, this is addressed to the chief executive, was it?
It is addressed to the chief executive.
And there's an FOI request to the chief executive saying, don't spend money and claim it back later, and I want to see the details under the FOI.
Yes.
Yeah.
And the response from the leader of the council, so I think I misspoke, it's the leader, not the chief executive. So it's an elected member rather than an officer.
Okay, so it's the leader, yeah.
Page 50, second paragraph, says...
But how does it begin?
The FOI-EIR process is not.
I have that.
And it's the fourth line down, the line starting above. And the next paragraph.
Yeah, and what do you get from this? This says you're not having FOI, but don't worry. We're looking at a range of different ways to make a coordinated improvement happen, one of which could be council funding work up front and then a legal agreement to get it back. So that's the response to the FOI request. Yeah.
What I get from those three documents that I just showed the court is that securing mitigation in terms of highways was a matter of public concern amongst some members of the community. This was something that people were bothered about, in simple terms.
But securing mitigation through highways was a matter of public concern.
Yeah.
Yeah. And that's Nicholson and Councillor Lilly and Penny Feathers.
Yes.
Yeah.
If we could then look at how the officer's report deals with the issue of highway capacity. The first officer's report is tab 18, starting on page 102, and highways capacity is dealt with under its own heading at page 152 to 153. And I emphasise paragraphs 147 to 52.
And 147 is the point you started with.
Yes.
There'd be capacity
Yes.
problems.
And what these paragraphs do is refer to the recent commission of a review of junction improvements, say that the council's aim, and you'll see this at 151, is to adopt suitable junction designs and then lead on to the delivery of a coherent and holistic junction improvement scheme at an appropriate time, which will be fully funded, or so it doesn't say fully funded, which will be funded by Section 106 monies that have already been collected and future contributions, direct works from nearby proposed developments. And then this, the Highway Authority has confirmed that the review is scheduled to be completed by autumn 2021. This was in July 2021, but this report on that point remains uncorrected throughout. That remains the statement.
No, hold on, isn't it? You're taking sentences out.
Sorry.
It's not helpful. We know about the capacity problems. 148, various data provided. Concerns highlighted again by Isle of Wight 149, and they're asking whether they're saying for the LPA, when considering the mitigation measures that are part of this submission, this application submission. The above issues considered when they looked at the other applications by the sounds of it. Then it says that each would have an impact on various junctions. Each development proposes slightly different highway improvement schemes to address their own impacts on the highway network. So each application has got a highway implication, and the concern is to coordinate it. So it's not like Thames Gas. You dig it up Monday, another one comes along and digs it up Tuesday.
Yeah.
So digging out of this, one, so far as the application for planning permission is concerned, each application has a mitigation process within it. And two, the council would like to coordinate that, so when they actually carry out the different developments, it'll be done in a logical way. Is that all this is saying?
That is what it's saying, but it's also saying how that's going to be done.
At the time they proposed a review, yes.
Yes, which we see from the bottom of 150 over to the top of 151, and suggested that the review is scheduled to complete in August, in autumn 2021.
So there's going to be a review, and they aim to schedule it for 2021, but that's not to determine whether or not planning permission should be granted. That's to try and coordinate the Highways Authority implementation.
Yes.
Yeah.
And then the recommendation, starting on page 167, under 8, is to secure it, including heads of terms, a financial contribution towards the provision of highway works to improve the Westridge Cross and the junction between Smallbrook Lane and Great Preston Road.
Yes, because to finish off the bits that you've been looking at and gone over, if we put the review to one side and how you're going to coordinate it, which road is going to be dug up first, the bottom line seems to be from 150 and 151 that there is going to be mitigation work for each development, and that will be funded by a contribution under Section 101. So that's the planning thing. There'll be mitigation work for the developments, and it'll be funded by a 106 agreement. And in terms of coordination of actual work, they're hoping there'll be a review to be completed by autumn 21. That's the position.
So the idea is, as my lord says, to avoid it being like driving down the road in London where it's dug up one day, put back and dug up the next. We're going to try and do this comprehensively. We'll get everyone to pay to a centralised pot of money, and we'll use that pot of money to do the job ourselves, and to make sure it's comprehensive. that is the approach, and then that is secured, or to be secured, through the financial contribution in the planning obligation, which is what the heads of terms point 1 deals with. So it identifies those two junctions, Westridge Cross and Smallbrook Lane, Great Preston Road, where there will be a capacity issue. So those are the ones that we saw in red, and says
that's where they need the mitigation. That's where they need a financial contribution to pay for the mitigation, and they'd also like to coordinate the details. They don't want penny feathers, if it is penny feathers, and it won't be now, digging it up on Monday, and Westridge are digging it up again on Tuesday.
Yes, and I mean, it may be even more complicated than that in the sense that you don't want to do a sort of half job of mitigation which doesn't work for all of the schemes, and it's not just digging it up, you just can't afford to mitigate because you've left a lacuna. I completely accept that.
But all this says is that there's going to be mitigation, and there's going to be a financial contribution, and the heads of terms is just the financial contribution from the applicant for 2 junctions.
Yeah, correct.
Yeah.
There's then a supplemental report in light of what Penny Feathers said. So that's the next tab, tab 19, and it's specifically page 184. And you have the nature of the representation, which is then the Penny Feathers representation.
Sorry, what page?
So 184, my lord, behind tab 19.
Right, and what do you want us to look at on this?
So the nature of, just to make sure I'm not skipping over anything, nature of the representation is a reference to the Penny Feathers objection, which we saw.
Right.
And then the officer's response is the bottom paragraph and over the page.
Well, it says, just so that we know, that the planning committee were actually told the planning commission should not require consent of third parties, and they shouldn't simply pick a collector for a scheme unless there's a clear scheme in place. They were told both of those things.
Yes, they were told that.
They were told the 4 options.
They were told that that's what Penny Feathers was saying.
Yeah.
Yes.
And then the officer conclusion, yes.
Yes.
Yeah.
And so, one, there is a suggestion of a costing by the developer here. It's the bottom of the first paragraph of the officer conclusion. Two, over the page 185, it says it would be unreasonable to require no works until the junction's improvements have been undertaken. So that's a response to the Grampian condition point. And then it said, it's noted that these figures, so that's the construction numbers, relate to the number of units on site without Penny Feathers, as this development would be required to do such works in the event it is commenced prior to these triggers. And then third party land is dealt with in the final paragraph.
So what do we get from that? That appears to raise all those points and to set out the officer's reports. They knew about the third party. They knew about the detailed improvements for this one, although they've given permission for other ones with just an in-principle one. They know what the applicant said the cost would be, and they know what the council says about the risks to third parties. All of those seems to be referred to, because you're coming on to this is materially misleading. It's all there, isn't it?
Well, it doesn't, because of the time that this was written, it doesn't say Penny Feathers is gone now.
No, but this is about the Penny Feathers objection.
Yes, so it's no part of my case that the Penny Feathers objection was ignored.
Right.
But I'm making sure that I've shown the court what was before, so that nobody suggested I'm trying to avoid doing so.
Right, okay.
So I completely accept that, and as I said, it's no part of my case on ground 2. That Penny Feathers objections were ignored. That's not what I said. The next document that I would like to look at is, and this is relevant to ground 1, behind tab 6 in the supplementary bundle. apologise, that's the wrong tab. It's behind tab 31. I do apologise. And this, the court may well have seen, is part of the correspondence from my solicitors with the local authority. And as you'll see from paragraph 1, it was sent on behalf of my client.
So this is March 2022?
March 2022.
So this is after the July 2021 decision, and this is shortly before the meeting that was called to see whether or not they were going to reverse it, and the Chief Executive Officer made a report about it.
Yes, my lord.
Okay.
And my client identifies, with reference to the Chief Executive's report, errors in the narrative. You see that from paragraph 8 and following.
But this really is history, isn't it?
Yes, I mean, I don't rely on that. The paragraph I rely on is paragraph 22 on page 295. My solicitors were saying, return this to committee. And then paragraph 22 says, we point out that in either of your two options, the final draft ready to be signed, section 106 agreement and draft planning conditions formulated by officers should be disclosed and circulated for consideration. Today this has not been done.
So in March 2022, the solicitor was reminding them of their legal obligations shortly before a meeting, which is not relevant to this application. Yeah.
Well, it's relevant to the application in the sense of the planning application.
Yeah.
Then if we could look at the board minutes, my lord, and so that's tab 36, page 337. This is
which tab? Sorry, which tab?
Sorry, tab 36, page 337.
Thank you.
So these are the board minutes for the directors of the claimant company on the 27th of April 2023. And it's page 338, 5.1.3.
Well, hang on, let's get an understanding. So this comes 4 days after the Planning Commission, and the business of the meeting is to do with the fact that the solicitors attended the 25th of April, the 2 days earlier meeting. That's the subject of the court case, and then issues in hand at 5, and various issues had been duly noted, starting with the curly mitigation plan and so on, yeah?
Yes, and just to be absolutely precise, my lord, it's 3 days after the resolution, not
After the resolution,
after
yeah.
the permission.
I stand corrected, you're quite right, yeah.
And it's paragraph 5.1.3 that I rely on.
Yeah.
And in particular, so as at today's date, email requests from residents on the issues set out in this clause have not been responded to, and it is hereby noted that certain documents have not been published on the council's portal, and this is the point that I make about you can only know that if you check the portal, my lord.
Yeah. This proves that somebody must have searched the register.
Yes.
Does it do any more?
Sorry, my lord?
Does it prove any more?
Well, it also at least asserts that email requests from residents on this issue have not been responded to.
On all the issues in the clause, but we haven't seen the email request, have we? We don't know if any email request was, please send this to me, and it wasn't answered. We just don't know, do we?
Well, we do have
No, from this document.
No, from this document, my lord, that is obviously correct.
Yeah.
But it is at least probative of there having been such emails. I accept it's not
No, it's
determined.
probative that there have been emails on these topics.
Yes.
We don't know what they are, and your client could have exhibited them if they were relevant.
Paragraph 3 deals with the costings, details of all necessary improvements.
Yeah.
What we do have behind tab 10, my lord, on page 52, 7th of July 2023, is the email from Mrs. Raymond.
Which page?
52, my lord.
Thank you.
So this is earlier Apologies, this is Leighton.
Yes. Is it the top one we're looking at?
Yes, the top
Yeah.
one.
Thank you.
Two requests. One, when the decision notice has been issued, and two, can you also send me a copy of the developer's road contribution agreement as approved by Island Road?
And this is the last in a series of emails. The first one is at the bottom an email to, this is the chief executive, I think, is it?
Yeah,
Yes.
yes.
And that says, why are you publishing minutes which aren't a faithful narrative?
Yes.
That's what it starts. Somebody replies to her saying, thank you for your email below. I confirm that a response will be sent to you shortly. You suggest in your skeleton that that refers to the email above.
I was
It's
wrong.
actually wrong, isn't it?
I was wrong, my lord, yes.
And then the thing is, she writes back to the person who's giving support to the chief executive, saying, can you send me the decision notice and the agreement? And that's as far as it's got. We know we've not got anything else.
There was no reply.
Well, how do we know that? Did she say that? It's just, did she
no, I
follow
don't
it
believe-
up? Did she then contact
I
the
don't
planning officer?
believe
We don't know anything, do we?
I don't believe she does say that in terms. No.
Can we just look at the content of the email, please? Just to see what the words actually used are. Asks for a copy of the developer's road contribution agreement
Yes.
as approved by Island Road.
Yes.
That gives at least me the impression that what's being sought is the final agreement. I don't read that as a request. Can I please see a draft agreement so I can comment on it?
Well, in my submission, she is asking for the agreement, and as approved by Island Roads means assuming Island Roads have approved it. She is asking for it so that she can comment on it, and I think we read this in the context of the minutes as well.
Right.
Sorry, hang on. Minutes were April. This is July. She's writing to the chief executive saying your minutes are false. It's a false narrative.
Yes.
She gets a message back saying I'll reply shortly. She then says I want to know the decision notice, and that must be a reference
To the
to when
final,
it's happened.
Sorry,
And-
to what?
to the
decision
final
notice.
decision, the issued planning permission.
That can only
Which hasn't happened yet.
No.
so that must be a reference to what's going to happen.
Yes.
And then she says a copy of the developer's agreement as approved. And you would say, despite what my lord has just said, and despite the fact that she's talking about the decision notice and the contribution agreement, she could have been asking for the contribution agreement before the decision notice.
Yes, and I say that's because she says, can you also send me? So they're dealing with two separate things. There's, could you explicitly let me know when the decision notice has been issued? And could you also send me, I infer now, a copy of the Section 106 planning obligation? And in my submission, she doesn't know at this stage whether it's been concluded or not. But what she's saying is, I want to see it now, and she assumes it will have been approved by Island Roads. And I mean, my submission is that that is probably intended to be something of a strong arm.
Well, forgive me, Mr. Streeton. One is not construing a statute or a contract or any formal document. This is just an email. But isn't it a reasonable inference that what it's interested, what its focus is on, is the decision notice, which is the grant of planning permission, and the road contribution agreement? It doesn't, to my mind at least, doesn't say, don't make a decision, don't issue the grant of planning permission before I've had a chance to comment on a draft contribution agreement.
No, but that had already been said by solicitors on behalf of my client
What, 2
Right.
years earlier?
2 years earlier in the...
Well, no, that was in the context of you've got two options of the meeting coming up in March where the chief executive has written a report. You've got option A or you've got option B, nothing to do with this, and a reminder that they've got obligations.
Yes.
This email isn't following on from that at all, is it?
Well, not directly, but it certainly is in the context of the ongoing narrative. Both pieces of correspondence forming a part of that narrative.
Right. Can I just check, Mr. Streeton? There's been a lot of questions for you from the court, but I want to make sure that you've got time to deal with your submissions? How are you doing on the timetable?
So, my lord, I am behind, but I also am pretty confident of picking up time on grounds 3 and 4, and so I am certainly confident of sitting down when I am meant to today. But I'm not.
That's not my concern. My concern is that you should have a fair opportunity to make the submissions you need to make.
I'm grateful, my lord. I am satisfied that I will be able to do that within my time estimate,
Good.
but I suspect I will not complete grounds 1 and 2 before lunchtime today.
Right. Okay.
My lord, the next point in the chronology is the issue of Planning Commission on the 4th of August 2023.
Yes.
That's dealt with at judgment paragraph 73, and there's no dispute that the planning obligation was not publicised prior to that.
Right.
It was received following pre-action correspondence from my client. That is pleaded in the statement of facts and grounds of paragraph 73 to 4, just for your note. It's tab 13, page 225 of the core bundle, and the contribution secured is in the sum of 406,359 towards highway improvements.
Right.
Following the bringing of proceedings, the council files witness evidence from Ms. Wilkinson, which is tab 9 of the supplementary bundle, starting on page 41.
Yes.
And in my submission, the key analysis is at 8, or paragraph 7 to 13. So if the court hasn't read those.
I've read them. I have to say, I don't find it always easy to understand what Miss Wilkinson is saying. I don't sometimes know whether she's talking about things she did for the officer's report or things she did for the Section 106 agreement. But I have read them on more than one occasion. Yeah.
What's the point or points you want to derive from this?
She firstly, in my submission, suggests that, this is paragraph 10, she is relying upon presentations to the Ryde Transport Projects Board, which is a body which my client doesn't believe exists. I'll make that good.
Does it matter?
Well, it matters to the extent that we do not know how these figures have been arrived at, and another point that I would make is that she does not really assist us with the detail. We in fact ended up getting that from the developer, and I will go there next. And also that she is, in my submission, relying on the pooling of contributions on a per unit basis, which assumes penny feathers will be brought forward.
And is she saying that about, this is what I was wondering, is she saying that about at the time when I did the planning report, or is she saying that's what she did for the contribution?
My understanding is that she's talking about it at the stage where she derives the contribution.
At doing the 106 agreement, or Dr. Ryde will tell us. But
Yes, that is what I believe she is saying, because of her reference to the per unit cost, which I don't think was an analysis which had been conducted at the time of the officer's report. Just in terms of the report that she says she has relied upon, so that's attached as her appendix, referred to at the end of paragraph 10, that's behind tab 11, and that was a document commissioning a project, which we see took place on the 26th of February 2020. And again, I don't know if the court has had the opportunity to read this.
What's the point you derive from it?
Firstly, that what is being suggested at this stage is that there's going to be a feasibility study by Island Roads which identifies how the mitigation works will be brought forward, including construction cost estimates and a delivery programme. and that the likely timescale for that this time was implementation by April 2023, and that if we look at the bottom of page 55 in terms of required dates, to facilitate the detailed design and agreement of section 106 and contribution rates with developer feasibility options and budget construction estimates, including statutory utility diversion and traffic management, are required by the end of July 2020. So what I say about this document is that there's a lot of work that was anticipated and commissioned, and it was anticipated that it would take place a long time ago, and nothing seems to happen.
What does it matter? This is not litigation between you and them over the details of this. You're arguing, one, that the publication deprived you of comment, and two, that the report published and then updated at various stages was misleading and misinformed members. This seems to be to focus on an allegation that the Ryde Transport Projects Board doesn't exist and they've invented the board and they're hiding something seems to me astonishing. And I don't quite see what this work note is saying things are going to be done by July. We're in 2024 now.
What it goes
doesn't
to,
seem to be central at all of this prejudice.
what it goes to is my ground too, because it's not just about the committee being misled.
Yeah.
It's also about the rationality and the failure to have regard to material considerations by the officer when they grant permission in reliance on the 106. Because this is the explanation, as I understand it, and Dr. Bowes can correct me, Ms. Wilkinson's witness statement is how she derived the contributions.
Yes.
And my submission is that it simply, essentially was not rational to say, well, I relied on having commissioned this work back in 2020, when in 2023 nothing had happened. It was obviously material that nothing had happened.
So you're saying ground two. Ground two is the officer's report.
Ground two is a failure to have regard to material considerations, not just by members,
No.
but by the officer in deriving the 106 contribution and granting permission in reliance on it. That's the point. It's not just.
Not just the report.
No.
Let me just look at ground one again and ground two.
I don't want to put words into your mouth. I really don't. I do want to know what your case is. Right? Just bear with me if you would. It is the essence of ground two on this appeal that there was an obviously material consideration, which was that penny feathers was not in fact going to happen now.
Oh.
Yes, that is the essence of the first limb, and the second limb.
Right. How many limbs are there?
Two.
Right.
So the first limb is
right.
penny feathers wasn't going to happen, and
Yeah.
that was obviously material.
Okay,
The
understand.
second limb is, and nothing had been done to work out what should happen
Right.
in the absence of penny feathers and in the context where there's a need for a comprehensive scheme. Essentially, my submission is numbers are being plucked out of the air.
Hold on. You've gone far too quickly.
Sorry.
One obvious consideration is one, penny feathers not happening.
Yes.
Two, nothing had been done to work out a comprehensive scheme. We've gone through that. The way in which they do it isn't a planning thing necessarily. They can decide the order and so on, but it doesn't mean they're going to refuse planning permission because they haven't worked out the precise order.
No, but the point is that at the moment of grant, when you are identifying a sum of money which you need, then you need to have some rational basis for the sum of money that you're relying on.
That's a fair point. And that, I understand, penny feathers. I don't see that the absence of a comprehensive scheme is necessarily the answer to you can't ever work out an appropriate contribution.
No.
So is it one or two? Is it one, as my lord said, or is it two as well? The absence of a comprehensive scheme or the absence of a comprehensive review, we sometimes call it.
It is two as well, and it's in the absence of a comprehensive review or some other rational basis. Because what we are told is there's going to be a review, that's the basis we're going to do it on. And in my submission, there wasn't the review. So it wasn't done on the basis it was being said it was going to be done.
But they can do it in a number of ways. They can say, we haven't done the review, we've got to take our best estimate, we've looked at the amount of the work, they've said 770,000, we think there'll be contributions from elsewhere, and that's where we'll come back to penny feathers, I promise you. There'll be contributions from elsewhere, we think 400,000 will broadly meet it. Is that irrational for and you haven't challenged the rationality anyway of the planning agreement.
My lord, I don't suggest that it cannot be done in other ways, and I think I say that in my skeleton in terms. But what I do say is that they did not proceed on the basis they said they were going to proceed.
Yeah, leave that to one side for the moment. Let's just work out what event we're talking about first of all in ground 2. Is the event that you're talking about the meeting or meetings of the planning committee?
Well, it's both. So if you look at the articulation of the ground,
Yeah.
so this is in the core bundle, tab
Page
1.
3, yeah.
So which page?
So it's page 3, my lord,
Of the.
of the core bundle.
Yeah.
And it's in the 4th line. It's failure by officers to advise members as to relevant matters, and or the failure by officers to take relevant matters into account. So it's both.
Yes, but I don't, the way it's written is opaque to me. Is that aimed at saying, therefore, the mental exercise undertaken by the officers post-April 2023 and entering into the agreement which they were allocated a responsibility for was unlawful? Or is it really all to do, because it seems all to do, with not telling the committee everything when they made their resolution? The first clearly must be that they failed to advise members. And the second is failure of officers to take relevant matters into account. Are you challenging there the planning permission simpliciter because the 106 agreement was wrong? And that was, if I go back to your statement of grounds and facts and I go to box 3, I would see that there, will I?
I genuinely don't remember what you'll see in box 3, but certainly the drafting of the ground of appeal upon which I have permission and the skeleton would reinforce this, was both. It was 1, materially misleading not to tell members, and 2, simpliciter unlawful because of what Miss Wilkinson says in her witness statement, which I say fails to take into account the penny feathers point, and also my second point, fails to recognise that there's been no progress on any of this for a very long time.
Right. No, Mr. Streeton, I'm very conscious of the time, and also that we've asked you a lot of questions. You were taking us through the supplementary bundle.
Yes.
Because you haven't actually got on to it.
No, I know.
No, I'm not complaining.
Sorry.
Right? I just want to know what the roadmap is from here on, because I want you to have a fair opportunity to make the submissions that you actually want to make. And for entirely understandable reasons, you've taken us through a lot of evidence.
Yes.
But I want to see where it's all headed. And I don't want to stop you.
No.
Because you must have the opportunity to show us, is there more in the supplementary bundle you want us to look at?
There are 3 further things
Right.
that I would wish to look
Right.
at.
That's fine, and I'm not going to stop you doing it. But please always bear in mind that the purpose of a hearing is to get to the submissions, right? So just always bear in mind why we're going to these documents, okay?
Yes.
And encapsulate, if you would, in 1 or 2 sentences, why we're looking at a particular document. Now, where do we go next?
Yes, so the first place is tab 29 on page 282.
Right.
This is the email correspondence deriving the contributions.
Yes. And what are we going to derive from this? Why are you referring
The
to it?
key point, my lord,
Yeah.
is that Penny Feathers
Yeah.
provides 42.95% of the contribution. You find that on page 284.
Sorry, 42.95%.
42.95%.
Yep.
So that's page 284. Heading, this then gives us the following totals and percentage splits.
Yes.
And Penny Feathers is 40.95%.
That's very helpful. Thank you.
And the contribution, the number, is at 283. So it's 1,381,200.70 is the total cost of the works as estimated. No idea where that comes from, but that is what it is. Minus 21,500, that's money already received. So then outstanding is 1,359,700. The tables do a calculation to derive a per movement price, essentially. And then that is what's used to derive the relative numbers of movements and to get to the contribution of 584355 for penny feathers, which is 42.95% as against.
But your headline point is the first answer you gave me.
Yes, it is.
That's why it's important.
That is why it's important,
Right.
but I just.
Yeah, it's sometimes important just to focus on what it is that matters to the outcome of this case, and that's fine. That's been very helpful. Right. So is that all on that document?
Yes.
Right. What's next?
I don't think I even need to turn up the next document.
Right.
It is simply the FOI request, which deals with the Ryde Project Transport Board. For your note, it's supplemental bundle tab 38, page 341.
Yep.
And the short point is,
Yep.
it says that the Ryde Transport Project Board does not exist.
Right.
And in circumstances where Ms Wilkinson is saying, we've worked this out very carefully.
No, we understand that.
Yes.
The point you're making is the board doesn't exist.
Yes.
Right.
And the
Go
third
ahead.
document is the witness statement of Mr Jordan, which is tab 7 in the supplemental bundle.
So hold on. When you give us the references, we just make sure we're actually getting it down, right? Supplementary bundle tab,
7,
Yep.
page 31.
page 31.
Yes.
Yep. And why are we going to this document?
So Mr Jordan is the cabinet member for Highways, PFI, Transport and Infrastructure. And you take that from paragraph 5.
Yeah, but why are we going to it?
Because Mr Jordan identifies that the Highways Authority does not feel it has been engaged with in deriving the Section 106 planning obligation, and that there are points he would have wished to make about it had he been aware of it.
Right.
So paragraph 9, he talks about the relevance of the lapse of the penny feathers application. Paragraph 10, he makes the point that that means if you need compulsory to acquire land, the cost is going to be even higher because you have to go through a compulsory purchase process and there will be inflation.
Right.
Paragraphs 11 to 12, he deals with cost inflation.
Well, we told that's taken account of in the obligation, but
Inflation going forward, but not inflation from whenever the contribution was first identified in 2020. It was then
Right.
to 2023.
so it's, hold on, it's penny feathers again.
So penny feathers 9, CPO 10,
And inflation 11 and 12.
yeah, and then 13 is no proper engagement with the highways team to establish costings.
Yeah.
And I think that same point is reinforced by paragraphs 14 to 16. So those are the points I wanted to make on the supplementary bundle.
Right.
And I can come back now to make my submissions on ground 1.
Yes.
On those facts, my essential submission is that the only reasonable conclusion, properly directing oneself to Article 43B, is that the breach vitiated the grant of consent. The judge at paragraph 78 gives 3 reasons for his conclusion to the contrary.
Well, what are your reasons why? All of the things you said.
I say that the statutory duty requires it to be made available for public comment. That is
Yep.
the purpose of the duty.
Yep.
That it was not made available for public comment, and therefore the purpose of the duty was undermined.
Yes.
And that there was prejudice to third parties, including my client, because there were things they would have liked to say. For example, what the cabinet member for highways was saying, which they did not have the opportunity to say. There was no substantial compliance, and there was prejudice to my client. Therefore follows in my submission that the intention of Parliament was that the decision should be quashed. That is my fundamental submission.
That's it, yeah.
And that's very helpful, if I may say so, because that pithily encapsulates ground 1.
Yes, it does, my lord.
And it's right or it's wrong, but we can understand it
That-
very
I can't improve
very
it.
easily. Yeah.
And that's the point. I have a response to the judge, because the judge found that there was substantial compliance.
Right. Let's just have a look at this.
So it's paragraph 78 of the judgment.
Thank you.
And in my submission, he makes 3 points. he says that the claimant has not shown that a copy of the Section 106 was requested, that it's not shown it would have said anything in detail other than in terms of highways impact mitigation, and he deals with that under ground 5. And he said that, as in Davis, he says it's Davies, it's Davis. The heads of terms were in the officer's report, and therefore there was substantial compliance. I'll deal with them in reverse order, if I may. So firstly, on substantial compliance, I say he's wrong in principle. Davis is distinguishable because in that case the specific contributions and the basis for them was already set out in the officer's report. Whereas in this case, that remained at large until the grant of consent. And so the purpose of the obligation to allow people to comment on it was undermined in this case in a way that it wasn't in Davis.
Yeah.
Secondly, in terms of prejudice and comments that would have wished to be made, the judge says he deals with those under ground 5. And what the judge says under ground 5, it's paragraphs 85 to 87 of the judgment, is the point my Lord Justice Lewis made to me as a matter of rationality, that a formal review is not the only way that one could approach this. But that, in my submission, is an error of approach. It is not correct to say that just because the decision taken was rational, there's no prejudice in not listening to what people might have to say. The whole point of allowing people to say things is that they may change your mind or improve the quality of your decision making. For example, by identifying that the penny feathers is now not going to come forward, and if the contribution is based on that, you need to revisit.
Is this going back to fundamental principles about procedural fairness, which is that we all know of cases that appeared to be open and shut?
Yes, that's cited in the ex parte Brent case, which was in Hogan's judicial.
Let's not worry about authority or case names or anything. What I'd like to focus on is what is the correct analysis,
Yes.
the conceptual framework with which we're dealing. Is your fundamental point under this argument that it's not enough to get the decision at the end of the day to be a rational one? Process matters.
Yes, absolutely.
And one of the reasons why process matters is because you don't know what the outcome will necessarily be.
Yes.
If you don't listen to people, you don't know what the outcome would be.
You don't know, and the court cannot second guess.
Your best part is the penny feathers. It was based on a contribution of 42% or 42.9% from penny feathers, and that's not there. And you would have said, hold on, check. Should you be getting more from Westacre? Should you be calling the whole thing off? It's not really the review, which is to do with the coordination. That's where you're confusing us, I think. Or confusing me, rather, not my law.
I apologise, my Lord. I would absolutely agree that penny feathers is my strongest point, and it is a clear illustration of the principle that my Lord Justice Singh is encapsulating, namely that you do not know what will happen if you listen to people. And an example of something people might have said, which could easily have made a difference in this case, is, well, hang on, what are you going to do now that penny feathers has expired?
That's your best point,
Yeah, okay. So that was dealing with the second of the judge's arguments. Do you want to say anything more about that?
No, my Lord.
All right. The first one is he makes an assertion of fact that you hadn't requested it.
Yes, and my submission is that is rationally insupportable in circumstances where the solicitors, at least, and I know it was in 2022, had written reminding the local authority of its obligation and in essence requesting. It's rationally insupportable to say that it was never requested.
But what the judge is really saying is, you never asked for it to comment on it. You, Greenfields, never asked for it to comment on. Other people might have, but you haven't asked for it to comment on. I know he's done it compendiously, but he's a human being, and he's just written a judgment, not a statute.
Yes.
And isn't that what he's saying? Isn't that broadly right? Your solicitor raised your obligation in 2022. Somebody asked for a completed document in 2023, I think it was, or 4.
3.
Well, the evidence shows what it shows, and my submission.
You've made your submission.
I've made my submissions on what it.
The evidence says. You say the evidence says what it says.
Yeah, it says what it says.
And we'll have to make of it what we do. It either makes good your assertion of fact or it doesn't.
But in my submission, I do not need to succeed on that, to succeed on the ground overall.
Because?
Because there would be prejudice. For example, in light of what Councillor Jordan, the Cabinet member for PFI, is saying he would have wished to say if he'd seen it.
I see.
And because my clients were checking the register, and I accept that it's contextually relevant whether you've requested it, so the prejudice might be seen to be more severe if you've requested it and not been given it, but it's not determinative because people are entitled to assume that the local authority will comply with its obligation. If they're checking the register, they don't think that the permission is going to suddenly be issued. This isn't a case, well it clearly isn't a case in light of the board minutes, where my client just had no interest in what the 106 said and is using it as a legalistic mechanism for challenging after the event. They've gone, aha, I found an arid technicality, I'm going to challenge on that basis. That is not this case. My clients did genuinely have something they wanted to say, whether or not they had said in terms, please can we see the section 106 and comment on it.
Right, well, we understand that submission.
And finally, is there anything you want to say about the judge's analysis of the fact that Pennyfeather's permission had lapsed? Because he makes comments on that, and just so we've got that clear in our own mind, why you say whatever he said about the Pennyfeathers lapsing didn't matter.
Yes, so that is really my ground too, but he is clearly an error of fact there, because he says it was an allocated site and it was not. It was in the so it had never been an adopted allocation, and to some degree I am considerably trespassing on my ground too here, but just to make the point.
I thought you'd made your ground one. Forgive me.
I have made my ground one.
All right. Well, then you're not trespassing on ground two.
You're
moving on to ground two.
I'm moving on to it, but I'm not taking it in the order I would have chosen.
No, don't worry about that. The important point is, have we understood what your arguments are?
Yes,
and I think we have.
Yeah.
Right. The ground two is essentially Pennyfeathers are dropped out of the picture.
Yeah.
And.
So. Ground two is Pennyfeathers had dropped out of the picture and was obviously material.
Right.
And the judge was wrong to conclude that the absence of progress between February 2020 and April 2023 was not obviously material.
So it dropped out of the picture. That's Pennyfeathers.
Yeah.
And the absence of progress, are we back to
the point that I was debating with my lord previously?
Okay, yes.
It's my skeleton paragraph 64b. Perhaps if I turn to deal with Pennyfeathers first.
Yeah, well, what more do you want to say?
Well, I want to address the point made by my Lord Justice Lewis that the judge takes the view that it wasn't obviously material in the circumstances.
Yes. And you say it obviously was.
I say it was.
Not these because it was going to contribute 42.95% of
yes.
the cost. What more needs to be said?
Well, the single short point I need to make is that the judge suggests that it was allocated. It was not.
Right.
My learned friend says, but it was an emerging allocation. And what I would like to do is show the court in the supplementary bundle what was said about emerging allocations in the advice, or in fact in the witness statement of Ms Wilkinson, paragraph 7, on page 43.
Sorry, which tab?
So, tab 9.
Thank you. Page 43.
43, paragraph 7.
Yep. And the point that you're making is
that the allocations were not given weight by Ms Wilkinson contemporaneously.
No, but she does say she gives weight to the background documents supporting the allegations. It's clearly not an allocated site. You cannot change the laws of the universe. But what they're saying, I think, in the judgment, and what they're saying here, and they may be right, they may be wrong, they may not be relevant, but it's pointless mincing words. They're saying it's not an allocated site, but it's pretty nearly as good as, because the background justification for it is there. And you're saying that's not right because...
I say that's not right because it hasn't even been out to consultation yet. And so we see this in the advice to officers on the emerging plan given at the meeting, and we can look at that as well. But my submission is this. Where your emerging development plan has not been out to public consultation, so you don't know what the nature of the objections will be and what will be required to resolve them, let alone going through the examination process and identifying the view of an inspector as to the soundness of the plan, you cannot place any material weight on the plan. And that, I say, is what she is saying in this first half of the sentence I identified. due to the stage in the process of the emerging plan, i.e. because it has not been out to consultation, let alone through the examination process. It is simply too early to place material reliance on it.
But isn't that a matter of planning judgment, not for the court?
It is a matter of planning judgment, but in my submission, there's nothing in terms of what was said contemporaneously to suggest anything other than what she says here. Namely, I didn't rely upon it. She says, yes, I understood the background documents, and in my submission, that, which is a reference to the transport assessment, is identifying what the highway's impact would be. It's not. Bear in mind that she, I think, was working on the basis that there was an existing consent for the development. It's not about what weight you give to the allocation itself. A point on the allocation is it's at this very early stage, and the same point was given in advice to members when they said we would like to rely on the emerging plan as a reason for refusal. I don't know if we need to go there, but for the court's note, page 198, row 96,
Yes.
there's officer's advice which says essentially the same thing, and it is a matter of planning judgment, but I think I don't need to make a rationality challenge here because it's ex post facto.
I think you're going further than you need to, because in a sense it doesn't matter to this development whether penny feathers exists or doesn't exist. If it doesn't exist, it might even help with the roads. But your point, despite the fact you want to do lots of other points, is that's all very well. But once they factored in the amount that penny feathers is going to put into the contribution, and once that has lapsed, and there's no guarantee it's going to come forward again, the problem is they haven't addressed Foursquare where the money is going to be made up from. That's the real reason, you say, I think, why penny feathers is relevant.
Absolutely.
And all the other stuff about the review and the emerging plan is irrelevant. There's a missing 42%, you say.
Yeah, that, in a nutshell, that is my point. Yes.
That's very helpful. So in fact, with 2 minutes to go, you have completed grounds 1 and 2, I think. But I don't want to stop you. If you have,
Yes, my lord.
if you have more to say on grounds 1 and 2, you must say
The only thing I haven't said is what I said I would say about my learned friend's paragraph 65, about my learned friend's skeleton argument, where he advances the argument which I say was not advanced below.
35.
Paragraph 35 of my learned friend's skeleton.
Not a third, Chris.
Right, let me just remind myself of what he says at paragraph 35. And why do you object to that?
Because it was not a point made below.
So what?
Well, and because it is inconsistent with what Ms. Wilkinson says here,
Right.
and that's why one of the reasons I wanted to go to paragraph 7, and because the compositions of the committees were different, and that's just the sort of thing that we would have wanted to address in evidence below,
Right.
had the matter been raised.
Right.
So we say it is
It's
firstly
too late.
too late.
Right.
And in any event, we say it's a bad argument, essentially for the reasons encapsulated by my Lord Justice Lewis when he framed my argument.
And in a nutshell, that argument is
That penny feathers was supposed to contribute 42.5%, and once the planning permission had gone, you could have no certainty you were going to get that money. And relying on the fact that it might come forward later pursuant to a draft allocation is not giving you the certainty you're going to get that
Or
money.
even a fresh planning application.
But, yes,
So
precisely.
they'll have an in principle earlier decision. If they wanted to build 900 houses,
Yes.
they're likely to get it, but they haven't put it in.
No. And it's not just that they have to put it in, it's that it will take a long time,
Yes.
and you need the money
Yes.
sooner rather than later.
Very
So, my
good.
Lord, I have
Mr.
completed.
Street, no, I won't hold you to that. If on reflection there's anything else you wish to say on grounds 1 and 2, you must, and you will have that opportunity at 2 o'clock. But I'm glad to see that actually we seem to be on track.
Yes.
Very good. We'll adjourn now until 2 o'clock.